All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save the United States, great state of Florida, and this honorable court. Ladies and gentlemen of the Supreme Court of Florida, please be seated.
Good morning and welcome to this session of the Florida Supreme Court. The first case on the docket today is Pincus versus American Traffic Solutions, Inc. Counsel?
Good morning, and may it please the court. My name is Brett Luskin, and I represent the appellant, Mr. Stephen J. Pincus, in this matter of certified questions from the 11th Circuit Court of Appeals. Your Honors, in 2010, the legislature of Florida enacted the Mark Wandell Traffic Safety Act, which enabled local governments in Florida to employ photo-enforced red lights on their roadways and set forth the parameters to which such programs must adhere. Following that, the city of North Miami Beach decided to avail itself of such a program, along with many other local governments in Florida. To accomplish that, the city entered into a written contract with the appellee, American Traffic Solutions, or ATS. Under that contract, ATS was to provide and perform all aspects of the photo-enforced red light program, including operating and maintaining the cameras, reviewing the footage for violations, issuing traffic citations, and receiving civil penalty payments from accused drivers for the city. In exchange for performing those contractual duties, the contract called for the city to pay American Traffic Solutions compensation in the form of a monthly fee. That fee is not at issue in this case. It should be self-evident that the city and ATS can agree amongst themselves in their contract how much the city should compensate ATS for performance of its contractual duties. It's elementary that they can do that. What they cannot do is agree amongst themselves in their contract as parties to that contract that someone else, a non-party, has to pay compensation to American Traffic Solutions.
Let me ask you this. This kind of goes to the heart of the case. The formulation you just made is that someone has to pay, or right?
Well,
I think those are the words you used.
Yes, according to the contract, yes, the accused driver has to pay this when they make an electronic payment.
So when they make an electronic payment, but it seems to me that would be the critical factor here is that the choice to make an electronic payment is entirely voluntary. Now, at some points in your briefing, you seem to indicate that there's a duty to make available as a matter of right, the ability to pay electronically. I don't know where that's written. If you could expound on that, that would be helpful. But it seems to me that this idea that's at the core of your case, that people were forced, you say they were shaken down, they were robbed, although you also say that this was your case of unjust enrichment does not depend on wrongful conduct. Well, I have a little trouble understanding how, on the one hand, you say people are robbed and shaken down, but it's not wrongful conduct that you're depending on. But explain to me how you get around the voluntary nature of this transaction that people enter into.
Certainly, Mr. Chief Justice. I think you've hit on the core of the case, and implicitly, you must understand, and this can't be overstated, I know we beat this to death in our briefs, but the relationship between American Traffic Solutions and Mr. Pincus and accused drivers is not at all voluntary. It's anything but voluntary. The only voluntary relationship in this case, contractual relationship, is between the city and American Traffic Solutions. And this is an important point. The American Traffic Solutions works for the city. They work for the government. They work against the driver. And that is fundamentally because a traffic citation is not a contract, and it's not an invitation to contract. On the contrary,
Well, I think the point is, you would agree that the $158 payment is involuntary.
Yes.
But what you're complaining about is a $7.90 payment, and that is completely voluntary because you could avoid it by paying a different way. I think that's the nature of the voluntary act that the chief was talking about.
Yes, Your Honor, and I think this is the point I'm trying to get at, that it's an illusion that this is voluntary. You have to realize that the accused driver, such as
How
Mr.
is paying the $7.90 fee not voluntary if you can avoid it by paying in a different manner?
Because
it is lawful.
Well, it's because American Traffic Solutions they are dictating the payment terms here. You have to understand that
They do not dictate that it has to be electronic. A person can send it in by mail. The traditional old-fashioned way, and a lot of transactions still happen that way.
I think that's a great point, Mr. Chief Justice. I'd like to touch on that specifically. You describe paying by mail by check as the old-fashioned way. And with respect, I dispute that. I think that is wrong. And the implication here is that there's some kind of minimum that American Traffic Solutions has to provide to accused drivers in order to satisfy its obligation to fulfill this government role. And the minimum, if there is a minimum, is not payment by mail. In fact, I would submit that it's cash.
Well, where's that written?
That was written in federal law, Your Honor. It's 31 USC 5103, I believe, which is legal tender, which says that U.S. currency is legal tender, good for all debts, public and private, taxes, and public charges and dues. Now, I recognize this isn't directly on point with the matter at issue today, but I do think that it's relevant and important.
But you haven't argued that point throughout these proceedings, have you? That's not the point. You're not arguing that somehow this is defective because they don't take cash.
No, I was trying to address the point that Justice Lawson made. But if I can come back to more fundamentally, the reason they can't do this, getting down to it, is that it's prohibited by state statute. State law says you cannot add any additional fees, fines, surcharges, or costs to civil traffic penalties assessed under Chapter 318, and is assessed under Chapter 318.
Well, why don't we go to that point then? If a penalty arises under a chapter of the statute, every place it is cross-referenced in the code, what does it mean for a penalty to arise under it?
That's an excellent question, Justice Coriel, and there isn't an easy answer for that because assessed under is not a legal term of art. So we have to determine what the legislature meant, what was the intent of the legislature in devising this particular statute. And the first issue is, was it assessed under Chapter 318? And we assert that it is by the very terms of 318.121, as well as Chapter 318 generally.
Help me out with that, because all I see in 318 is a reference to the fact that the fee arises, or the charge arises, under Section 316.
Okay, so there's several arguments here. First, 318.121 it strictly prohibits additional fees, fines, surcharges, or costs, except for 5 exceptions that are enumerated in the statute. The last of those exceptions in 318.121 is specific to red light camera cases under 316.0083. So as a starting point, it's what I describe as the classic exception that proves the rule. There is an exception where the legislature permitted precisely one additional fee that can be added to red light camera violations.
Would you concede that if Section 316 didn't provide for this penalty, that the penalty wouldn't exist?
If Chapter 316 did not provide,
Yeah.
Are you referring to the penalty?
Imagine that 316 is amended, but 318 isn't. And in the amendment, the surcharge, the whole red light scheme is struck out of 316, but for whatever reason, the legislature doesn't make a correction to 318, or at least not yet.
Let me try to answer that. So if all of 316.0083 was vacated, then there's no mechanism for local governments to have photo enforced red lights to begin with.
So
But
doesn't that mean that this really arises under 316 and not 318?
no, Your Honor, and here's why. Because the provisions that the penalty provisions that we're talking about in 316.0083 that specify that that there's a $158 civil penalty, those very same provisions appear virtually identically in 318.18. So it appears in both statutes. Only the wording is very slightly different, but all of the provisions are identical.
I'm sorry to interrupt you. Does it matter, though, that 318 by its terms only deals with citations, and this was a notice of violation, which is a precursor and a way to avoid a citation?
I
So
don't.
it seems like to me the whole notice of violation construct is completely a creature of 316. And 318, just on the face of the text, it's talking about people who are cited, and then in 318.18 it talks about penalties when there's a citation. So it seems like, at least in this case, and I don't know if it gets to the citation stage, I don't know how the payments work on that, but you brought this at the notice of violation stage, which seems to me is completely outside of 318.
And to answer that, the answer is no, Your Honor. The notice of violation, the amount of the civil penalty for a notice of violation is $158. And that sum, the $158 that's applicable to a notice of violation, that appears in both 316.0083 and 318.18 sub 15, I think 2 and 3.
But in that context, though, in 318, it's clearly referring to penalties where there's been a citation.
Well, actually, I disagree with that.
Well, I mean, you can disagree with it, but and this is super in the weeds, but when you look at it, you'll see that it's specifically talking about for citations.
If Your Honor will give me a moment, I will pull the statute and I can walk through this.
Okay.
I recognize that this is a little bit tedious, but in 318.18, which is entitled Amounts of Penalties, we have to skip.
It says for a non-criminal disposition pursuant to section 318.14. So then when you go to 318.418, it says any person cited for a violation of chapter 316, blah, 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 is charged with a non-criminal infraction and must be cited for such infraction. So this is all at the citation and beyond stage. And the notice of violation is pre-citation.
That is true. The notice of violation stage is pre-citation, but I understand the reference, Your Honor. But in 318.18 sub 15,
right? But you don't get to 15. You got to start at the beginning. The penalties required for a non-criminal disposition pursuant to section 318.14, and then it has colon, and then it does 1, 2, 3, 4, 5. So.
Your Honor, I'm not trying to mince words with you. I recognize that this is a little bit tedious, but if I walk through the legislation in 15A sub 2 and 3, you will see that that's not what they're referring to here. These statutes that I'm pointing to refer directly to 316.0083 by their terms. It's just that it's a little bit circuitous to get there. So just if you bear with me, sub 15A3 says 100, this is the amount, $158 for a violation of section 316.74 sub 1 or section 316.0751C1, which are the red light statutes that are applicable. When a driver has failed to stop at a traffic signal and when enforced by a county's or municipality's traffic infraction enforcement officer. So this is the important language, traffic infraction enforcement officer. So to understand what that means, you then have to go to the definition section in 318, if you excuse me for a moment, which is 318.13, sub 5. Here we go. And what that says, in sub 5, it describes an officer and says that an officer is a traffic infraction enforcement officer. It includes a traffic infraction officer that is defined in the definition section in chapter 316. If you give me a moment, this will just take me a moment here, Your Honors. 318. Okay, 318.13 sub 5. The second sentence in here. Officer includes any individual employed by a sheriff's department or police department of a chartered municipality who is acting as a traffic infraction enforcement officer as provided in 316.640. So now again, we have to reference 316.640. And 316.640 in the relevant portion, defines, just a moment. Okay, this is in sub B3. Okay, for the purpose of enforcing 316.0083, so now we're back to the red light camera law under 316, the department may designate employees as traffic infraction enforcement officers. And then there's a description of what these are, which essentially describes them as being responsible for issuing notices of violation for violations of red light cameras. So I recognize that this is a little bit difficult to parse, but I will represent to the court that when a uniform traffic citation gets issued after the notice of violation stage, the amount due is not $158. It follows the standard protocol under 316.075, and the total sum goes up to, I believe, $277. So it's a bit tedious to work through these statutes. But the point I'm making is that under 318.121, both by its terms, its own terms, and 318 generally, and the relationship between these statutes was clearly intended by the legislature to apply to photo-enforced red lights. And that makes sense considering that the entire Florida Motor Vehicle Code is designed to be a uniform set of laws applicable throughout the state, with each chapter dealing with a different aspect of the traffic law.
Counsel, you are now consuming rebuttal time. You may keep going, but you need to be aware you're in the rebuttal time.
Thank you, Your Honor. I will conclude here and resume my rebuttal at the end. Thank you.
May it please the court, Joseph Lang from Carlton Fields for American Traffic Solutions, Inc. With me at counsel table from the State Solicitor General's office is David Costello. I'm ceding 5 minutes of my time for Mr. Costello to address the money transmitter statute if the court wants to talk about it. We didn't get that far at the beginning. I'm happy to answer any questions on any parts of this, but I'll try to focus on what we just talked about. But at the outset, I want to emphasize, especially given the ideas of extortion and embezzlement that were in the reply brief, I want to make clear so everybody understands, this notice of violation was for $158. $158 was collected, $158 was received by the city, and it was apportioned exactly as it was supposed to by the statute. Nothing was siphoned off. That's not even what this case is about. This case is about what happens after that notice of violation arrives at the violator's house, and the violator has to choose how to pay it. And the violator has many options that don't have any fees. Money order, check, no fee involved. You just pay the violation. But what you don't get when you send a money order or send a check is any sort of immediate verification that the fee is paid. You can't know for sure that the postmark made it. And that's important when you wait until the last day, as Mr. Pincus did in this case. The record reflects that this was paid on the last day. So an additional option that ATS offers with the authorization of the city through their contract is that you can pay online with a credit card or over the phone with a credit card. And when you do that, as is very common in the world today, there's a convenience fee associated with that.
Does the convenience fee also apply to debit card transactions, out of curiosity?
As far as I know, if you're allowed to use the debit card at all, it would apply, but I think maybe this is a credit card only situation, but I think any electronic payment would have the convenience fee.
So what you're buying, the convenience that the fee includes is the convenience essentially to wait until the last minute. You're buying time. Is that a fair statement?
I think there's more than that. Time, but in different ways. First, you don't have to have out-of-pocket money when you pay. If you can pay on a credit card, you can pay that over time.
That was why I was asking the question about the debit card.
Right. you also get the immediate notification that it's been paid, a verification that it's been paid, which gives you peace of mind, especially if you're on the last day, but peace of mind whenever, that it's off my plate, I don't have to put it in the mail, I don't need to get my stamp, I don't need to get my money order if that's what it's going to take, it's done. And so there is real benefit here, and if we get to it, I'd like to talk about why that benefit by itself is a benefit of the bargain that precludes the unjust enrichment cause of action that is going on here. Unjust enrichment is about mistaken transfers. There's nothing mistaken about the payment of this convenience fee. This was a knowing choice by Mr. Pincus. Nobody says that he paid more than he was told he was going to pay. He chose to make the convenience fee payment when he used his credit card. So this doesn't really fit unjust enrichment at all, but because what we talked about in the initial part of this argument is 318, I'll jump to that. Happy to answer any other questions, and I would like to touch just a bit on unjust enrichment at the end.
Counsel, before you do that, let me ask you, what do you think, if the court decided to rule in the city's favor, or ATS's favor, what would be the narrowest way for the case to be decided?
The narrowest way would be where I was going to start had we gotten there, and that is the benefit of the bargain doctrine. That would resolve this entire case because all three causes of action are based on unjust enrichment. And the restatement, to start with, black letter law, Florida courts, I don't think this court has ever adopted the restatement of restitution and unjust enrichment, but we have Florida courts that have cited it, and it's very well respected. Black letter law says that if in an unjust enrichment situation, if there's been counter performance, then meaning benefit of the bargain has been given, there is no unjust enrichment. We cited a long line of cases from the 11th Circuit and the federal district courts, including one state court case, a 5th District Court of Appeal case that I believe, Justice Lawson, you were on the panel for. And this doctrine has been uniformly adopted. Mr. Pincus did not grapple with those cases. He tried to make one distinction of the Batista case in his initial brief, and we showed why that distinction didn't work. And in the reply brief, Mr. Pincus just ignores the entire line of cases and tries to set this case apart as being different because he was compelled to deal with ATS. And while he was compelled to pay the violation, he was certainly not compelled in any way to choose to pay with a credit card. He could have paid with a money order or a check and not incurred the fee.
I'm sorry to interrupt you though, and I know we're not bound by it, but isn't there some tension between the benefit of the bargain argument and the Silver Star 11th Circuit case? I mean, in that case, it didn't say, at least in the face of the opinion, there wasn't any issue about whether the services had been rendered that the insurance company was being charged for, but essentially the court said that you could have unjust enrichment based on the fact that that the statute made the fees not chargeable given the ownership structure of the company. So, I mean, the benefit of the bargain thing, that seems like an attractive avenue, but am I missing something about how that relates to the case, to that 11th Circuit case?
As far as no, Your Honor, it's a great question because I've questioned how Silver Star came out the way it did, because it would seem the benefit of the bargain doctrine should have barred in that case too, but the 11th Circuit did not grapple with that. It didn't mention Baptista, its own Baptista case, didn't mention Pereira. It just didn't deal with that line of cases. And so while there may be some tension, it's largely because they didn't address it. They have these other cases on benefit of the bargain, and it either wasn't raised or they overlooked it, but it just did not come up in Silver Star. But Baptista, Pereira, and then the federal district court cases, you have a settled line. We, of course, think that Silver Star was decided wrongly under a different argument of unjust enrichment, the more general argument whether unjust enrichment can exist at all. We would say that it's just the wrong vehicle, the wrong cause of action to address a case such as
Well,
this.
let me ask you this. What if it was not voluntary, like in this situation, that the ability to send checks or a money order without paying this additional convenience fee was not there, or they charged the same thing for whatever method of payment? Is that a violation of the statute?
A mandatory
Yes.
fee? Yes, I think a mandatory add-on would be a violation of, depending on what it looked like, I would say that it would either violate the commission, or if it's the vendor that's getting the mandatory add-on, I think.
So if that's a violation of the statute, and that seems right to me, it seems to be a good argument for unjust enrichment in that case, because it would be in violation of the statute collecting a fee not authorized.
I think the way the court ought to look is whether that statute creates a private right of action.
Well, we have common law causes of action for unjust enrichment, don't we?
There certainly is a common law unjust enrichment, but the problem here is the third prong. The first prong is that the plaintiff gives a benefit. The second prong is the defendant has accepted that benefit. The third prong is that it's inequitable for the defendant to keep that. The whole argument for inequity here is that a statute was violated, that the wrong...
Exactly. So in answer to Chief Justice Kennedy's question about the most narrow grounds, it seems to me the proper way to look at this to see, first of all, whether there was a violation of the statute. No, because it's voluntary, and then you never get to the unjust enrichment claim. Wouldn't that be the proper way to analyze this?
The court certainly can get there that way, answer it in the order that the 11th Circuit certified the questions. To do that, you have to rule on three different statutes. I guess that's the reason I would argue that the benefit of the bargain doctrine, because it covers the entire case, to get there on the statutory ground, because he has three different counts. He has a Chapter 316 count, a Chapter 318 count, and a Chapter 560 count. Now, I, of course, believe that the fact that this is a voluntary optional payment settles all three of those statutory arguments, but the court would have to address all three statutes to get there from the top down.
Did the city need to have an affirmative grant of authority to set up this mechanism in the first place? And if so, is it 215, 322, and does this comply with that?
No, we're aware of 215, and local governments can utilize Section 215. This fee is not limited like the convenience fee in 215. It does have a profit element to it. And out of candor to the court, you need to understand that it would not satisfy the Section 215. I think Section 215 is interesting because it indicates that convenience fees are understood by the legislature, and they're all over the place out there. As far as where is the authority to do this, obviously the legislature has authorized these type of programs. I mean, that is Chapter 316, 0083, and understands that vendors are going to be operating these programs. You can see that in the specific prohibition against vendors getting a per violation payment. They don't want to incent vendors to get a payment that's based on a per violation.
How can I, so I understand, I'm very sympathetic to what you're saying about the private right of action, but how would, if it were an illegal charge, but something voluntary, like let's say that the 318, 121 argument were meritorious, what would be the proper way to have cities stop charging that fee?
Right. If there is no private right of action, which is assumed, I need to make that clear. It's assumed in this case that none of these three statutes has a private right of action.
And I don't think the other side
and I don't think they've
disputes
even
that.
argued otherwise. Then it becomes agency enforcement.
Right. What agency, though?
Department of Highway Safety and Motor Vehicles has the responsibility to enforce Chapters 316 and 318. And under 316, they have a more specific responsibility to monitor these programs, to issue an annual report, and to make recommendations for legislation that may be needed if they see problems with the way this program is running. So Department of Highway Safety and Motor Vehicles for Chapter 316 and 318. And as my colleague will explain, it's the Office of Financial Regulation for Chapter 560.
Okay.
Counsel, let me go back to the unjust enrichment. Has any Florida state court ever recognized an unjust enrichment claim based on a wrong arising from a statutory violation?
No.
Why would someone be wrong in thinking about claims associated with statutory violations in light of whether there is an express cause of action, and frequently there are express causes of action, or an implied right of action, and not try to shove this into such matters into the framework, which does not seem to be a comfortable fit with unjust enrichment. The history of that, all the circumstances related to that, the way that is set up, what would be wrong with looking at it that way?
We agree that unjust enrichment is a very ill-fitting cause of action for this. We think that the court's jurisprudence about private rights of action would capture these types of situations, and if the legislature either expressly or impliedly wanted there to be a private right of action, there are ways to deal with that under the law. What this is going to do, if you recognize unjust enrichment as being a vehicle for these kinds of claims, you're going to see claims like you rejected in QBE brought under unjust enrichment. That was a case where they tried to bring a violation of a font in the insurance code as a private right of action, and this court said there's no private right of action there. What you're going to see is attempts to bring that font violation as an unjust enrichment claim if these are allowed to go forward. We believe that the test ought to be, is there a private right of action? And if there is, then you go forward that way. You don't even need unjust enrichment at that point. But certainly in cases where there's no private right of action, we don't think there's a fit here. And I can answer any other questions. I see I'm out of time. Okay, I would like to cede some time to the state. Thank you.
Mr. Chief Justice, and may it please the court, David Costello for the Office of Financial Regulation. First, I'd like to make clear the office agrees with ATS. Mr. Pincus cannot state an unjust enrichment claim based on the money transmitter code. But I'd like to touch on a point that you raised, Justice Polson, and that's whether a statute can ever support an unjust enrichment claim. And we think that it can. The first step is to ask,
what basis in the jurisprudence of the Florida courts do you have for that position?
Well, I think Murphy recognizes that position, Your Honor. There, the court recognized there was no statutory cause of action, but there was a statutory obligation. There, it was a statutory duty. And the court recognized that that statutory duty could support a common law negligence claim. And so it just recognizes that statutes can support...
We're talking about unjust enrichment here.
Of course, of course. And
no one's contending that there can never be an implied right of action arising from a statutory violation, right?
I agree with that, Your Honor. I don't think that that's what Murphy stood for, though. I think it was simply recognizing that the common law, it's constantly evolving, and it can adopt and adapt to modern standards, and sometimes the best standards are the ones that have been recognized by the legislature. And so if you take that premise and also note that this is recognized in the restatement in section 44 at illustration 12, it recognizes that there can be unjust enrichment claims based on statutory violations, even when there's no statutory cause of action. And so the question then becomes, when does that happen in the context of unjust enrichment? And you don't need to look further than the elements. A statutory violation results in unjust enrichment when the defendant will have inequitably received a benefit from the plaintiff as a result of the violation. And I think you were touching on this point exactly right, Justice Polson. If a violation of a statute renders a certain charge unlawful or unenforceable or void, that is the quintessential scenario when someone is holding on to a benefit to which they have no legal entitlement.
But how does that square with the whole concept that unjust enrichment isn't supposed to be fault-based in the first place? I think what the Chief's questions are kind of getting at is that whether there's a remedy that you might be able to find, this particular remedy just doesn't, it seems just kind of categorically designed to deal with other situations.
Well, I do want to be clear, Justice Muniz, that that does not turn on fault. In that scenario, if a defendant is holding on to something that it's not lawfully entitled to have, we don't care so much about whether the defendant is at fault.
But I mean, they violated so in this case, no one's arguing that, they didn't get, there wasn't some benefit conferred by, the fee and all that, and getting into the weeds of how much did that cost and all that. I mean, the only reason why we're even having this conversation is because it's the illegality, arguably, of charging the fee that makes it unfair to keep it, right? I mean, isn't that basically what you're talking about with statutory violations? I mean, that's the problem. I mean, that's what makes it a problem in terms of the injustice of keeping the money.
I understand your question, Justice Muniz. I think what's key here is that we are not living or dying, so to speak, on the statutory violation. It is the result of the statutory violation that results in unjust enrichment. So if you take Silver Star, for example, there you had a licensure scheme, the violation of which led to an underlying transaction being void or unenforceable. We don't care so much that the defendant violated the statute. What we care about is that now there is no basis for the transaction in the first place. There's no legal basis for the defendant to be holding on to a particular benefit. And so,
only because the statute was violated. The arguments that try to separate the violation from then what happens afterward, I just don't know. I mean, it doesn't matter, but I just don't understand that.
Right, and of course, Justice Muniz, if that were a holdup, we think that the cases that are standing for that proposition are federal district court cases, and we don't think they should hold this court back here. I do want to note, though, that even if a statute creates a legally protected interest, as we've used it in the briefs, I think another way is just to say that it's setting up an unlawfulness scheme, a situation where a benefit would be held unlawfully as a result of the violation. Even if the statute protects individual interests, nevertheless, the legislature can preempt common law. It can take that violation off the table. And we think that's entirely consistent with the restatement's position, and this is in Section 44, that if the legislature intended for something to not be actionable privately, then it cannot be actionable privately. And so if you just look at the statute here, the one we're in the case on, the money.
Well, see, what I'm struggling with is the gap between saying there is an implied right of action and somehow that the legislature did not create an implied right of action, but they didn't preclude claims arising from the violation through some other mechanism.
I see I'm out of time. Can I respond?
Yeah, please.
I think that the key here is that the legislature, we're not looking to whether the legislature has created anything new. That's what we look to when we look to legislative intent. Did the legislature intend to create a cause of action? But here, we already have the cause of action. It's a common law cause of action for unjust enrichment. And so if, as a result of a particular violation for which there's no statutory cause of action, someone is just holding on to a benefit that, as a result of the violation, there is no justification to hold on to, then the common law elements of unjust enrichment are just naturally met in the first place. And just to close, I will say that I think there are reasons why the legislature would choose to take a common law cause of action. For one thing, common law causes of action are time tested. There is plenty of case law to rest on. Statutory cause of action, they need interpretation. And second, common law causes of action have inherent limitations that statutory causes of action might not have. So, for example, in Murphy, there was no statutory cause of action for negligence, but there was a common law cause of action, and the court found that important because that bound that claim in the economic loss rule. But that might not be present in a statutory cause of action. So for those reasons and the reasons in our brief, we ask that you find for ATS on the money transmitter issues.
Thank you. Rebuttal.
May it please the court, just a few brief rebuttal points, Your Honors. Mr. Chief Justice, you asked a direct question to counsel for ATS. Has there ever been a decision in Florida state courts where unjust enrichment was used to recover, I think I'm stating this right, was used to recover an illegal fee or tax imposed under color of law? The answer was no, and that's not correct.
I asked about a statutory violation. That's the way I framed the question.
Okay. Well, the response from counsel for ATS was no, and that is not correct. There have been a number of cases out of Florida state courts where unjust enrichment was used in this way. Now, I don't believe there has been any precedent out of this court, but there are numerous decisions from DCAs throughout the state that support our position on this. And that falls into the doctrine of...
Give me your leading case.
Okay, the leading case I would say is Bill Stroop Roofing, which is, I can give you the citation.
That's the whole illegal exaction line of
Yes,
stuff.
illegal
but those
exaction.
But those aren't unjust enrichment cases. I mean, at least they aren't, the courts don't talk about them that way.
Well, I would say Parker versus American Traffic Solutions, which admittedly is a district court case, has a pretty good summary of this. And so just reading this here, he described, Judge Moreno starts, unjust enrichment is
I asked about Florida state courts. I love Judge Moreno, but he's not a Florida state court judge. He's a federal district court judge. The whole question was focused on whether the state courts of Florida have recognized such a cause of action.
Yes, Your Honor, he's citing to Bill Stroop Roofing. I just thought this was a better summary of the holding of that case.
Well, but you can't bootstrap it that way. If the underlying case is not talking about unjust enrichment, it doesn't fit the bill, does it?
Well, no, Your Honor, but Bill Stroop Roofing was an unjust enrichment case, was it not? I believe that it is, and I think that's why Judge Moreno was discussing it that way. And in fact, reading from Bill Stroop Roofing, the court says, in addition to this prospective relief, however, Stroop is also seeking a refund on behalf of itself and others for previously paid illegal fees, to which claim Miami-Dade County responds that it is protected by its sovereign immunity. That is, the county claims that it's a sovereign, and it can properly demand and extract monies from its citizens. Then
I think that is an illegal exaction case, right?
Yes, Your Honor, but I believe that illegal exaction is a doctrine that falls under the heading of unjust enrichment. I mean, if the problem is just that we've entitled the cause of action incorrectly, I mean, that's just an amendment problem. But I do believe it falls under the same heading of the court-fashioned equitable cause of action of unjust enrichment.
Are the elements the same?
I'm sorry, say
Are the elements the same?
The elements are not, there are no discrete elements that are discussed in the case law pertaining to illegal exaction, to my knowledge. But what I will say is that counsel said that it's the wrong vehicle to obtain redress in a scenario like this, and I think that's incorrect. And I think this case gives the court an opportunity to codify this.
Well, the unjust enrichment thing is the only, I mean, that's the hook that would, I think, probably unsuccessfully, but at least it gives you an argument about the voluntariness not being an issue. I mean, the illegal exaction line puts this in a situation where, since this obviously was not something that you were forced to pay, you chose to pay, you could have avoided paying it, the illegal exaction stuff is just completely unhelpful to you in that way. So I don't think that it's just a semantic thing.
Well, if I'm understanding, you're saying that in the typical unjust enrichment case, it's unhelpful to us because it's voluntary.
No, what I'm saying is in any illegal, you're saying in an illegal exaction case, all of those cases are things where the government said, if you want a license, if you want to do this or that, you must pay X amount of money, and the court said that X amount of money was not legally charged. So in that sense, there was no question about voluntariness. What I'm assuming the reason why you choose the unjust enrichment thing is to possibly make the voluntariness or not irrelevant. Just the pure fact that it was a statutory violation, even if you paid it voluntarily, makes it unjust to keep the money.
Yes, right. I see that I'm out of time. May I just
You may answer his question.
answer that question? So that's correct, Your Honor. And I still dispute the characterization of it being voluntary. But in any event, getting back to the point you were making, that the voluntariness of it somehow vitiates the unjust enrichment claim, I think is wrong. Because, and going to the point you were making, that
It has to be premised on it. How could that possibly be wrong?
well, okay, so unjust enrichment is, as has been stated, is not about fault. It's not about the violation. It's simply about money being in one person's hands that should be in another person's hands. And I think that we satisfied that in case. There's $7.90 that's in ATS's hands that should be in Mr. Pincus's hands because it was unlawful for them to impose any additional fee, fine, surcharge, or cost, and illegal to collect a commission for all the other reasons. So With that, I'll close, Your Honors. Thank you.
All right, thank you. We thank you all for your arguments in this case today. The court will now proceed with the next case, Sievers versus the State of Florida.